Ms. Smith, if you could let us know when we're going live.
You're live.
Thank you. Okay, let's go on the record on cause number DC 1917681, First Mercury Insurance Company versus Needham Roofing Incorporated. Council, make your appearances.
Yes, Your Honor. Steve. Oh, I'm sorry.
Your Honor, this is Morgan Madsen appearing on behalf of the plaintiff, First Mercury Insurance Company. Sorry, Stephen.
No worries. This is Stephen Fields appearing on behalf of Needham Roofing, and it's our motions here today, Your Honor.
Let's go ahead and proceed.
Okay, Your Honor, there's two motions. I believe one's dispositive. I don't know if you want me to address them simultaneously or have the court hear them separate.
Whatever you prefer.
I'll start with, I think the motion to show authority is dispositive. And if I can give the court a brief background on how we got here. My client is a roofing contractor and he has to get liability insurance part of his business. He solicited and bought liability insurance from First Mercury Insurance Company. And there's a total of 5 policies. All of them were sequential and renewed thereon after the end of the policy period. The ones in particular are, I believe, the 4th policy and the 5th policy. Each time my client would renew a policy, he would pay what's called a premium deposit. And so it's basically, it's kind of an expectation of what his sales would be for that policy period. And they factor that, and then he makes a upfront payment. At the end of the policy period, if there's if he made more in sales, there's an adjustment or an audit or he reports it to him, and then they calculate what's owed or if there's credit remaining for the policy period. For the policy period of which First Mercury brought suit on, I believe it's policy 04. They asked for, they said there's a deficiency between the gross sales and deposit premium. Renewed it, my client paid the upfront deposit premium for the 05 policy. And then thereafter, First Mercury canceled my client's policy, and then subsequently started getting letters from CoverX Corporation requesting payment of the outstanding for the 04 policy. And in particular, attached to our motion, there was a letter from Barnett and Garcia, which stated which appears that they represent CoverX Corporation. Thereafter, the lawsuit was brought against my client by First Mercury Insurance Company for the outstanding premiums owed under the debt. We also counterclaimed for not refunding the deposit premium on the 05 policy. And we also, and also for insurance code violations as well. Going through the file, it seemed like all the correspondence coming from Barnett and Garcia, it appeared that they represent a different entity than First Mercury Insurance Company. I think it's the CoverX Corporation, but we haven't seen any, hasn't been any assignment of the debt and or any pleadings thereon to that effect. About August of last year, I conferred with Mr. McCarthy, who I think was lead counsel at the time, and asked him if he'd produce documents to show authority, because we believe they didn't have authority to represent First Mercury in this lawsuit. He told me over the phone he would. I didn't receive those documents, and then we included them in our request for production as kind of just to make sure, we had official in writing for them to show authority. Those documents weren't produced, and at the time there was only 8 pages of documents produced by FMIC, and it didn't even have the policies that they were suing on, or the policy for the one that we are suing on. And also
Mr. Fields, did you read their response?
Yes, sir. Yes, I read the response.
And I mean, it seems to be they have an affidavit that says that the CoverX had the assignment from First Mercury, and so I'm not sure what we're arguing about.
Well, Your Honor, we also had a couple objections that we filed today in our reply to to the affidavit submitted. One is Miss D'Ambrose, probably butchering Miss D'Ambrosio. It doesn't appear that she works for First Mercury, she said she works for Crum and Forster. So we think that's all hearsay, and also it's based on conclusory statements. A couple of them, one in particular, in paragraphs 3 and 5 of her affidavit.
She says, I work in billing and collections accounting unit at Crum and Forster. Crum and Forster is comprised of several insurance and companies and related entities, including First Mercury Insurance Company and CoverX Corporation. I mean, I'm just not, okay, go ahead. It seems fairly clear cut, but go ahead.
Yes, Your Honor. With that, I mean, it may be a parent company, but we also, in our request for production, which I'll go on to, we also asked for any agreements and any, to show any, if they have a relationship with CoverX or Crum and Forster, to produce those documents as well. And so we know who's actually, how this suit applies. And we objected to paragraphs, one in particular is paragraph 5. It doesn't answer the ultimate question. It says the law firm of Barnett and Garcia is authorized to prosecute this lawsuit against Needham, but it doesn't say who authorized it. And I think that's the ultimate question. I think only First Mercury can authorize this suit, regardless of corporate structure. And we have our objections are filed in our reply to their response to the, and we don't think they met their burden in showing that First Mercury has given them any authorization to bring the suit.
Do you want me to rule on this now, or do you want to discuss the discovery you think you still need?
We can do a joint. It does whatever the court prefers.
What do you prefer?
I'll argue my other motion to compel, and then I guess we'll have them response, and then we can rule thereon, if that's okay.
Okay.
On our motion to compel,
So there's 46 requests, is that right, in the motion that you're objecting to?
Yes, Your Honor.
And have you conferred with the other side about these 46 requests?
Yes, Your Honor. I sent a letter and requesting conference, and I think that's the what I saw in the response. I think the big issue, there might be some communication, because apparently they state in their response that they conferred with my boss, Mr. Lori, in an email, but didn't CC me on that one. I then again conferred on February 8th, which is attached to my motion. I asked them if they're going to be supplemented, because at the time they said they're going to supplement the documents. We didn't receive any documents. Mainly what we're looking for is the underwriting file, any agreements to, like I stated in my motion, to show authority, and some of their accounting on what's been done, and also
Are these the requests you're objecting to here?
Yes, Your Honor. Their First Amendment response. Your Honor, may I see the certificate of service on if the court would bear?
Certificate of service?
Yes. Okay. So, Your Honor, this one was attached to their motion, and it states that it was, or the response, it said it was by e-service, email, and certified mail. And the supplementation here, my office has not received, and I checked my e-service. I got no notification that this was supplemented. And I believe they've attached the 400 documents. So I think at the time they've supplemented their response, but our other question that we moved in the alternative is I don't think it was timely, because one and that's the other objection I have to both responses. I don't think they're timely under the local rules. Also, we're set for trial March 30th, and I just received these documents in their response on March 12th. It says January 6th, but I checked with my under the email chain. It says it was emailed to Mr. Laurie. I checked my boss's file, didn't find it there. Haven't received any a certified mail or the e-service for any of these responses or the documents that were produced thereon.
Mr. Matson.
Yes, Your Honor. This is so confusing because none of this we should not be here, Judge. I'm sure the court has much more substantive matters to get into. With respect to the motion to show authority, the court is absolutely right. I mean, as the court is probably aware, these Rule 12 motions are for instances where, example, you might have a partnership and one partner hires a lawyer to sue the other partner, but the suit is in the name of the company. And so the other partner being sued is like, wait a second, why is my own company suing me? And then there has to be a motion to show authority where that lawyer has to have proof that the company or the partnership filed suit. This is not that case. I took great pains to make the affidavit pretty crystal clear while also making it succinct so that we could move through this because we should not be taking up this time. I mean, I've identified who she is. And I think the important part of this, Your Honor, is if you do you have access, or I can show the court via a share screen, but attached to Ms. D'Ambrosio's affidavit is a letter that she wrote. It was attached.
I read the letter. I mean,
okay.
So I'm going to deny the motion to show authority. I'm not really even sure why that was filed. But the second issue is there's 41 requests. There's been 400 pages of documents, it sounds like, that have been produced. The expectation is on these is that you go through each of these individually. Now, I'm not fussing with you, Mr. Matson. Your firm does have a reputation of being very difficult to reach. Sometimes I try to reach them when there's some kind of emergency motion. It's almost impossible to get an attorney on the phone. So I don't know if that's been part of the issue. Mr. Fields hasn't said that, but what I'm going to do, given that concern, unfortunately, you're going to have to pay the price for the way the firm is structured. I'm going to put you guys into a breakout room with Ms. Smith, and you guys are going to confer on each of these, go through all of the discovery. I'll leave this link up. If you guys can get done with that, and I want Ms. Smith, I want them to go through each and every one of these 41 requests and the documents responsive to each. And then if you can get that done in the next 20 minutes, you guys can come back into this room. If not, you'll need to come back tomorrow morning at 9. And Rhonda, if you could go ahead and email them the link for the trial docket tomorrow, and I'll go over it with you then. But you need to go through each and every, when you're doing, Mr. Fields, I know you're not from Dallas, but when you're doing a motion to compel, you need to speak to the other side. Now, I don't know that this has happened. I've heard in many other occasions where people have tried to reach attorneys at Barnett and Garcia, and it's been very difficult to do. I don't know if that's why you didn't confer. That's not my impression, but you need to confer on each and every request before you bring it to the court. So I'm going to put you into a breakout room with Ms. Smith. Ms. Smith's going to make sure she's not going to make any rulings because she's an intern. And I'll send Mr. Atchity in there as well. They're going to make sure that you go through each of the 41 requests, that you discuss them, figure out what you have and what you don't have. And then if you can't reach an agreement, I'll hear the rest of it after you've gone through each of the 41s individually. And either we'll handle those today or tomorrow morning. Does that make sense?
Yes, Your Honor.
I think that's reasonable, Your Honor. If I may ask, would it be permissible for me to see if I can also get the associate who was originally working on this, Ian McCarthy, to also appear in this breakout room? Because some of these individual ones he may have some particular knowledge about. I just want to be
sure. I don't have a problem with that. It's you'd have to get him on the phone pretty quickly because once I'm done with the next hearing, I'm not going to be on this link, so I don't know who would let you in.
Okay.
But
okay.
He can't come into the office with you, or are you working from home?
Oh no, I'm in San Antonio. And so I was brought in on this issue because of some of the difficulties you're talking about. The firm is, yes, notoriously busy with certain things. It's not of any disrespect to any counsel.
Or judge.
Or judge, yes,
I
Your
can't tell
Honor.
you the number of times I've called Barnett and Garcia, and I get some receptionist on the phone and she leaves me on hold. And I'm like, you treat judges this way? How are you treating other attorneys or debtors or whatever? So it's not, I understand why, because you have such a volume, but you need to figure that out. I'm not fussing at you, but just the frustration I've had with this firm in the past. So, but Ms. Fields, Ms. Atchity, if you could just stay on, or do either of you have to leave at a particular time?
I don't, Your Honor.
No, sir.
I mean, I was asking the interns.
Oh.
Okay. So they're gonna supervise you. Ms. Smith, I think you have my cell phone. If there's a big problem, text me. But I do want them to go through individually each of the 41 requests, not you need to produce everything and the other side says, no, I'm not going to produce it. And then that's over. They need to go through each one individually. Does that make sense? Okay. All right. I'm going to put you in the breakout room. And Rhonda, can you email Stephen and Mr. Fields and Mr. Matson, can you put your email address in the chat so that Rhonda can put her email address so that she can, or so she can email you the link for tomorrow in case you don't get done today. She may already have it, but let me see. Oh, one other question I have before we do that. So the trial setting's on March 30th and it's a jury trial, I believe. Is that correct?
Yes, Your Honor.
We're not going to have jury trials on March 30th. The newest pronouncement from the local administrative district judge is that we're going to be starting jury trials in August. I'm hoping that will maybe move up somewhat, but that's the current pronouncement. Do you want to go ahead and just move this jury trial, or do you want to come on the 30th and talk to me about it? But it's up to you.
I think if we're not going to, as much as I'd like to get this pushed, Your Honor, if we're not going to have it and we can get that issue resolved today, I would rather do that.
I'm fine with that, Your Honor.
When do you want to be reset to?
Let me get my calendar.
And I don't mind discussing this with you tomorrow if you're coming back tomorrow, but we also, you may not be coming back tomorrow, so.
I think the one I had in September just got moved. I think I have an opening in September, as you know.
So as of right now, again, this can change. The September trials will only be 6-person juries. So
Okay.
I don't know if you guys can agree to a 6-person jury. If you can't, then it would need to be after October. I would suggest maybe November 30th or November 23rd. Those are relatively open on my docket, at least for now.
My preference would be for November 23rd. That's just probably right before Thanksgiving. I'd rather do that.
Oh, wait a minute. I'm sorry, November 16th or November 30th. November 23rd is the week of Thanksgiving. It's the 16th
Okay.
or the 30th.
Yeah.
Yeah, you don't want the week of Thanksgiving.
No.
Sir. I would prefer November 16th.
Yeah, November 16th would be fine this year.
There's a Matt Garcia signing on. Is he with y'all?
He is a principal in the firm, Barnett and Garcia, Your Honor.
Oh, maybe did you hear me complaining about the firm?
He did not, but you can be assured that I will let him know. It looks like he's connecting now.
Okay.
Or feel free to tell him, Your Honor.
I didn't even know that I'd ever met him before. Mr. Garcia?
He's a good guy and he's a friend of mine from law school.
Okay, hello.
Hi.
Sorry about that, Your Honor. I'm not dressed, and I apologize to everybody for not being dressed.
Are you here for the 3:45 or for the 4 o'clock?
I am with Morgan Matson's office.
Oh, did he text you to say that I was fussing with them about not being able to get anyone on the phone when we call your office?
Yes.
Okay.
But he didn't say you were fussing. He just said that we needed to make some changes.
Well, it's a serious problem. I've had a number of times where we've called your office and we can't get anyone on the phone, or I get put on hold. And I mean, if you're doing that to judges, there's a serious problem. I mean, there's been a number of times where I've just made rulings because I couldn't get an attorney on the phone. And I know you have a huge volume and I understand that, but to treat judges that way, Mr. Mattson, hopefully you feel I've been respectful to you, Mr. Mattson, but he's bearing a little bit of the brunt of this, that he's going to have to stay here. I'm not letting him like do this by phone just because of the history with your firm. It's so hard to reach people that, so that's what I was chatting with him about. It's a serious problem. A lot of the judges talk about it. So you need to figure out something, in my opinion. Maybe you don't care, but
No, I do care and I do appreciate it. And I didn't realize it was a problem until, I mean, I really didn't know. I do know that other firms like me have an option where judges are able to press a button to kind of exit things. And that's something that I've looked into but haven't done, and probably going to look into as soon as I get off the phone with you.
I would recommend that, and to train your people that the judge gets, they treat me like, I mean, and I'm not fussing because I'm a judge and I'm so important or whatever, but when I look at it and I think, okay, a debtor is telling me that they've had problems reaching people and that's why they didn't do something, I always believe them because that's how I get treated as a judge. And I would assume that most judges, I think I'm at least average niceness among judges. Some judges some judges won't even call, I'm sure. I at least try to call to say, hey, look, your person isn't here, or we have a TRO or whatever. And almost invariably, whoever answers the phone puts me on hold or doesn't get the person or treats me like I'm, kind of less than human. And I'm like, wow, I'm a judge. This is really frightening if you treat me this way, what are you doing with everyone else? And so you just.
Well, I appreciate the feedback because most judges wouldn't even tell me what you're telling me. So,
Well,
so I appreciate that, and I'll make some changes, and I may even probably follow up with you to let you know what changes I've made. So I appreciate the feedback. I'm here and I am ready. So let me know how the court would like to proceed, and I can.
We're just going to put you guys into a break. We're just putting Mr. Mattson and Mr. Fields into a breakout room because they need to talk about some discovery. I don't know that you need to be there for that, but to the extent, I don't have anything else to say about the phone calls. But the reason I'm doing it this way is that my worry is that Mr. Fields won't be able to reach Mr. Mattson. Although, are you even with Barnett Garcia? I don't even know.
No, I am, Your Honor. I'm of counsel with the firm, but I'm in San Antonio. Mr. Fields is in San Antonio.
Okay.
And so I'm easily accessible. I make that representation to the court.
So I unfortunately, given my past experience with your firm, I don't fully believe you, but I want to, it's nothing against you, but just this firm. And so that's why you need to meet with him right now and go over all of these and make sure that you guys can communicate about them, because if you're going to handle cases, you have to abide by the same rules as everyone else does. There's no special rules because you're in a certain field. Every other attorney has to show up to DWAP dockets. Every other attorney has to, confer on motions to compel. Just because you have a lot of cases doesn't mean you don't have to do that. So, but I don't take this personally, Mr. Mattson. It's not directed at you. It's just.
No,
Your Honor.
I take responsibility. It's my firm. It's my name on the door. So I appreciate that. And like I said, I do appreciate your candor. I didn't realize it was a problem, but thanks. I really do.
Okay. Well, all righty. Well, good. Well, I'm going to put you guys in a breakout room, and Ms. Smith, text me whenever they finish. Okay.
Yes, Judge.
Thank you. Thank you, Judge.
Thank you, Your Honor.
Good luck getting it all worked out.
Oh, Your Honor, did we get confirmed for November 16th? Just to make sure.
Oh, yes. Rhonda, go ahead and reset it to November 16th. And Rhonda, did you get their email addresses so you can send them the link for tomorrow?
I believe that's gone out already.
Oh, you've already gotten the link for tomorrow? Okay.
I did see an email come through, Your Honor.
And I need to set Mr. Fields too, right? Okay, link has been set. So I'm setting Mr. Garcia, though Mr. Garcia, I don't think you really need to be here for that part. Mr. Atchity, Mr. Madsen, Ms. Smith, and Mr. Fields. All right, guys, thank you so much. And will get your case reset, and hopefully you guys can get this all worked out.
All right, thank you, Your Honor. Are
Okay,
we
guys.
getting assigned a breakout room right now?
Yeah, right now.
Okay.
You going to a judge now?
Okay, Mr. Mims, Mr. Tarabi, you're here on a motion for continuance.
Yes, Your Honor.
Mr. Mims just went away. Is he your opposing counsel?
He is. Yes. Is he? I haven't seen him on here, but I can't see everybody, I don't think.
Did I accidentally send him to the breakout room? No, he just,
He just went.
there he
AWOL,
is.
huh?
Okay, he just came back.
So I'm sorry, Judge, you were saying, I got a phone call while I was listening in on that prior one. What were you saying was the latest on jury trials for Dallas?
So the latest, this could change tomorrow. I just want to make this clear. And this is not Judge Hoffman. This is our local
Oh, right.
administrative district judge has told us that trials will start. The first summons are going to go out in July for August trials that will be limited to 6-person juries. And then we'll be doing regular trials starting in October. I'm hoping that will get moved up some if the numbers continue to improve in the rapid way that they have been. Mr. Mims disappeared again. But that is as of 3:14 p.m. on March 15th, 2021.
Right.
That is the current policy of Dallas County.
Wow.
If you asked me a week ago, it would have been different, but this is the newest pronouncement from her.
Well, I'll tell you, yeah, things can change overnight for sure. But that's interesting. They're at least targeting August. I don't know. We'll see, I guess.
I mean, I think we're going to be, I mean, other counties are moving much more aggressively. So we're going to be, I think, near the tail end of people trying cases. The numbers are changing pretty rapidly. So,
Right.
you know, if we get obviously, if things get worse or whatever, and these variants turn out to be, you know, resistant to the vaccines, then all bets are off. But given what we're hearing from the doctors, the public health folks here in Dallas, that's kind of what this is based on. I don't know why Mr. Mims keeps coming in and out.
Maybe he's got a connection issue, it sounds like. Well, how did that, I guess you're the first one in Dallas, aren't you, that did the jury trial by Zoom, right?
I did. I thought it went pretty well, but I think we've decided just to hold off and do in-person trials. I thought we were going to do hybrid trials where we'd do jury selection remotely and then the trials in person.
Mhm.
Currently, that's not the plan. This may change. That's what I want to make 100% clear, because
Sure.
I thought what we were going to do is once we got to Orange, we were going to do hybrid trials, but the newest email is contrary to that. So I honestly don't know for sure, but I do think that this is kind of a very, very conservative approach. So we'll get, at the latest, we would have October trials and
Right.
smaller trials. But again, this is a constantly changing thing. Mr. Mims, are you there? You're having some internet issues.
I am. It's coming in, and every 2 or 3 minutes it'll kick me out and then reconnect,
What-
Judge. But
Well,
here
since
now.
we're
Can you
having
hear
that,
me?
when do you want to be reset to?
Your Honor,
You mean the hearing?
I'm actually,
Is this a jury case or non-jury?
it is a non-jury, I
Non-jury.
believe.
So I'd
Yes.
like to get this tried before August then.
Yeah, and Your Honor, the only issue
Yes,
for,
Judge.
go ahead.
Go ahead, Mark. I'm sorry. It's
No,
your
no, we're,
motion.
the only issue, Judge, we've just got some new discovery, some phone records that Mr. Mims obtained that we just received last week that necessitate us bringing in some new parties. I don't anticipate having to do a whole lot of additional discovery. We've already deposed one of them. We're going to need to redepose another. I think August, if we can do, if the court has time for late August, that would be preferable for me because I have another case in the federal bankruptcy court that's going August 4th, I think. And
My fear is that if the schedule holds, I'm going to be trying jury trials as many as I can, as frequently as I can, as quickly as I can. So once just give me 1 second. Mr. McCarthy, I'm going to go ahead and assign you to the breakout room with everyone else, okay? I'm going to try to do that. Let me see. There you are. Okay, you should have gotten an invite. Did you get one? Great. Good luck. So, if possible, I'd like to get this set in July.
okay. I am just looking at my calendar to make sure I'm not forgetting something, but I don't see anything in green. So I think I should be good for maybe, can we do mid-July?
Sure, but I mean, again, this could all change and it may not matter, but the more you move it back, the more likely you're going to get flooded with these trials, these jury trials. So July 19th, how does that sound for everyone?
That works for me, Judge.
Judge, let me kind of give you a brief statement on what our issue is with the delay. Number one, this Mick Cyrus guy, he's the same guy who gave them a general warranty deed and has been deposed, and I don't know why they had brought him in the suit. He's the guy who said he gave him good title, and he didn't. I think we all know at this point we're dealing with a forgery. The delay is going to bring about, it's going to unnecessarily complicate issues of damage mitigation because we can't get defendant to agree to sell the property. Everybody understands that this was, defendant was in it to sell the property. My client was in it to make the profit. But presumably they're going to amend and now add some additional claims. One of these claims is going to be for some damages. We deposed him on page 70, I think 69 of his deposition. He said he lost the file, so he doesn't have any additional expenses. I'm hoping we're not dealing with a found file.
Mr. Mims, I can't understand you. I'm so sorry. Your internet's going out.
I'm sorry. Can you hear me better now?
When is this set for trial again? Is it March 30th?
No, it's that tomorrow.
Oh, tomorrow. Okay.
And so we're going to presumably now 6 more months. I'm assuming somebody's making payments, which we shouldn't have been making those for a year now. We should have sold this property, put the proceeds in the court's registry, paid the lien off, and then had the issues. That's, and I don't know why we can't do that, and we're dealing with. So the longer we delay, the more we're going to have to litigate this issue of damage mitigation. That's my primary concern.
Brief response, Your Honor. Yeah, the only reason that we're being delayed in terms of making any kind of agreement to sell the property are the demands by plaintiff. They're putting all kinds of demands, and their claims to entitlement to damages. There's no rational relationship that I can see to that and any authorities that I've been able to find. But the bottom line is we're willing and I've proposed the sale of the property and put it into the registry. I proposed that out, I don't know, 8 months ago at least.
No,
but every time, including at mediation, we're constantly met with these demands that the plaintiff's daughter has to be the realtor that listed, and they has to be listed for a minimum of $500,000, and they have to get $25,000. There's all this. The bottom line is we're in
Incorrect.
a situation, we want to get this tried as well, and we want to get it tried as quickly as possible. And I don't think that July, that's what, 3.5, 4 months, to add 2
4
new
months.
parties. Yeah, I mean,
Judge,
we're moving this thing along, Judge. I think that's a reasonable request.
Well, if Mr.
There's
Mims
a-
doesn't
there's a
agree, then I
motion.
don't know if I want to move it. Mr. Mims, do you not want any extension?
if
What do you
we, Judge, I'm not trying to be unreasonable about, their claims. This Mitchell Cyrus guy, I mean, he should have been brought in a long time ago.
By the
My point
plaintiffs,
is
it
this.
should have been brought in.
No, the plaintiff
I'm
didn't
not the
receive a
plaintiff.
warranty deed from Mitchell Cyrus. Yeah, I'm the plaintiff, but plaintiff didn't receive a warranty deed. We have no privy with Mitchell Cyrus defending this.
Mr. Mims, when do you want it to be set for trial?
Well,
You want to go tomorrow?
we're ready to go. We will agree to the continuance if they will agree to have the property listed and sold. That's our point. We filed the motion on July 20th of 2020. It's in the docket of miscellaneous requesting this specific relief. Sell the property, put the funds in the court's registry. So we've been trying to get that done for a year now. If they agree to do it, if they'll agree to list the property with a third-party realtor, we'll agree to, or if the court can assign one. And the proceeds after the lien are put in the court's registry, we're fine. But to go down this line, continue delay, and then, we got all these damages, we're not prepared to do that, Your Honor. So it's up to them if they want to agree to list and sell, third-party realtor, we're fine. Other than that, we just need to go.
Your Honor, this agreement has been made. I've requested this agreement for 8 months now, and every time I get the same story, yeah, we're on the same page. And then when push comes to shove and we have to document it, then all of a sudden all these crazy conditions come in. And that's the problem, Judge. I'm happy to sell the property too.
This court, we're both officers of this court. I'm going to produce emails requesting this. I'll ask Mr. Tarabi to provide any document to what he just said.
I'll
Any
provide your
you.
letter to me, Mr.
Wait,
Please.
guys. Let's just settle down. You guys are getting kind of heated here. What I would suggest we do is, I want to try cases, especially non-jury cases. And so I would suggest you guys show up ready for trial tomorrow. If you guys can reach an agreement based on Mr. Mims' conditions or however you want to do it, I'm okay with moving it. But if it's not agreed to, it's going to trial tomorrow. So you guys need to figure out a way to reach an agreement or you're going to trial. So do you want me to put you in a breakout room, or Mr. Mims, your internet is really bad. It's very hard to hear you, but do you want to?
I can call Mr. Tarabi on the phone. Hopefully we can reach a Rule 11 agreement. No conditions, third party realtor. We have to agree to it. We're not going to agree to his real.
What part of town is this property in?
I heard you. If we can't agree, then we're going on.
I'm sorry, Judge.
What part of-
Cedar
I couldn't
Crest.
hear him. Mr. Tarabi, did he say it was in Cedar Ridge?
It's right across from the golf course. Yes, Your Honor.
In Cedar Hill?
Cedar Crest.
Cedar Crest.
It was Cedar Crest near Cedar Hill?
Yeah. Well, Mr.
No.
Mims. Yeah, I don't know.
It's near Cedar Crest Golf Course. It's near Cedar Crest Golf Course, Your Honor, in Oak Cliff.
In Oak Cliff. So
Yeah, and
you guys can't agree to a realtor. Who I usually use for that area of town is a realtor named Katie Hubner.
Okay.
KYHUBENER. I'm not ordering that. If you guys agree to someone else, I'm perfectly okay with that. But if you can't agree to somebody and you want me to pick one, that's who I used for that part of town.
Okay.
She's a former justice of the peace and a longtime realtor, probably 30 years of experience and very experienced with that area of town. But if there's someone else you want to use, I'm perfectly okay with that too. I would suggest I could either put you in a breakout room, but I think that wouldn't work very well because Mr. Mims' internet connection, but you would need to come back tomorrow and just either be ready for trial or have an agreement. Okay.
just to be clear, I mean, Your Honor, I'm the defendant here, and I mean, we're talking about damages. We're the ones being damaged. So I don't know what Mr. Mims's point is on this damage thing. I mean, they bought a lot for $25,000, a vacant lot at a tax sale. My guy constructed improvements on there, and it's now worth $400,000. And they're talking about their damages. My guy's the guy paying interest on the loan, not his client. So I don't really
No,
understand the whole premise of his argument.
I'm not
Well-
discussing the merits. I'm just saying, hey,
Yeah.
look, if you don't have an agreement, you're going to trial. If you do have an agreement, I'm glad to move it to July,
And what time
Okay.
is it tomorrow, Your Honor? Is it 9 a.m.?
9 a.m. And you should have a link already. If you don't already, you can get it from Rhonda.
Okay.
Thank you.
All right, guys, good luck, and we'll see you tomorrow.
Thank you, Judge.
Either way, you
Thank you.
need to show up tomorrow, though. Just so you, even if you have an agreement, you need to show up tomorrow at 9.
Absolutely, Judge. Thank you.
Thank you,
Thank you.
guys. Be safe.
All right, you too, Judge.
Samantha, I'm going to go ahead and put you into that other breakout room. Because I think it's really good experience to watch those types of negotiations. Because if you end up being a civil litigator, you'll be doing a lot of discovery negotiations. Unfortunately, it's part of the less exciting part of your job, but unless you have to leave right now.
No, I don't have to leave.
Okay, I'm going to put you in the breakout room.
Okay.
All right, you should have gotten an invite.